Good afternoon, everyone. This is a re-recording of the End of the Statutory Demand CIGA 2020 webinar that myself and Alexander Heylin did on the 11th of February 2021. I am Maria Mulla.
And I'm Alexander Heylin.
Before we jump into the body of the presentation itself, I think it's important to introduce, first of all, Alex. Alex was called to the bar in the year 2000. He was called to the bar in Turks and Caicos in 2011, in Cayman in 2015, and in the BVI in 2016. Alex deals with all large-scale litigation and insolvency matters, many with a cross-border element, and has been involved in many high-value, multi-jurisdictional insolvencies. Alex has also practiced as a partner in an offshore law firm before joining a law firm in New York. And finally, Alex has just finished a 2-week virtual trial in the High Court, defended a claim brought by a liquidator on behalf of a respondent who is accused of fraudulent trading and dishonest assistance. So Alex, that's your introduction.
Thank you. So yes, for Maria, Maria was called to the bar in 2005, and she specializes in commercial litigation and insolvency. She also likes to be involved in cases with an international aspect. Like myself, she likes to get involved in a wide range of commercial disputes. She also was the first barrister to set up a barrister-led ABS, which is still operating today. And she was recently seconded to Sydney for a year to assist a company and its law firm on their litigation strategies, where she worked in the courts in Sydney, Perth, and Melbourne, and it will soon be admitted to the bar there in Australia. And she's just recently returned from a trip to the UAE, to Dubai, and is going to be undertaking cases soon in the DIFC. The purposes of the webinar today is to have a look at CIGA 2020 and to have a look at the legislation itself, and then have a look at the case law. As you'll see, there's not a huge amount of case law on this at the moment, but Maria's had a very recent case, which she was successful in, which we'll go into during the webinar. We'll also go over some practical tips in relation to both bringing these sort of claims and defending them. So the slides should have already been made available to everyone. We're working off the same set of slides today. If for some reason anyone who hasn't watched the original webinar, the End 10 original webinar, doesn't have slides, please feel free to contact our clerks, our marketing team, and they will make available. I'll hand over to Maria.
Thank you, Alex. And as Alex said, there's not going to be a Q&A, but we're still more than happy to answer questions. So if you have any questions following this, please do pop them on the email, and we will come back to you. So effectively, the main legislation in this area is the Corporate Insolvency and Governance Act, CIGA 2020, which came into force on the 25th of June 2020. And effectively, the Act suspends the issuing of wind-up petitions and statutory demands from the 27th of April until the 30th of September 2020. Now, we know that that period was extended until the 31st of December 2020, and then it was further extended until the 31st of March 2021. One of the key questions, I guess, is will this period be extended again?
Yes, and obviously we haven't heard yet on the data recording whether it's going to be extended. I've heard unofficially that it might be extended to the end of April, but there's whether there's any substance to that is at the moment unknown. As no doubt you're all aware, originally The statute was till September, and then it got extended till December, the end of December, and then till March, which is about 6 weeks from now. So it'll be interesting to see whether it gets renewed for another 3 months, which is what's happened before, or if it's for a shorter period, for a month, which sounds like might be possible, then maybe that will be the end of the road for CIGA. And we'll probably find out, I imagine, around the budget at the beginning of March.
Yeah, and I think Alex and I do intend to do a follow-up to this webinar, because we do feel that there will be more cases and more things to deal with potentially in and around March and April. So do keep an eye out for that.
So just carrying on with the legislation in terms of the text of Schedule 10, so we get on to paragraph 2. A creditor may not, during the relevant period, present a petition under Section 124 of the 86 Act for the winding up of a registered company on a ground specified in Section 123, 1 subsection A to D of that Act, the relevant ground, unless the condition in subparagraph 2 is met. And subparagraph 2 reads, the condition referred to in subparagraph 1 is that the creditor has reasonable grounds for believing that A, coronavirus has not had a financial effect on the company, or
B, the facts by reference to which the relevant ground applies would have arisen even if coronavirus had not had a financial effect on the company. And subsection 3, a creditor may not, during the relevant period, present a petition under Section 124 of the 1986 Act for the winding up of a registered company on a ground specified in Section 123, 1 subsection E or 2 of that Act, being the relevant ground, unless the condition in subparagraph 4 is met.
So continuing paragraph 2, subsection 4, the condition referred to in subparagraph 3 is that the creditor has reasonable grounds for believing that A, coronavirus has not had a financial effect on the company, or B, the relevant ground would apply even if coronavirus had not had a financial effect on the company.
Paragraph 5 is also very important, and this paragraph applies where subparagraph A creditor presents a petition for the winding up of a registered company under Section 124 of the 86 Act in the relevant period, and the company is deemed unable to pay its debts on a ground specified in 123(1) or 2 of that Act, and C, it appears to the court that coronavirus had a financial effect on the company before the presentation of the petition.
And just to conclude paragraph 5, the court may wind the company up under Section 122(1) subsection F of the 86 Act on the ground specified in Section 123(1)(e) or 2 of that Act, only if the court is satisfied that the ground would apply even if coronavirus had not had a financial effect on the company.
So we had the implementation of CIGA, and then obviously following that, there was the new Insolvency Practice Direction, which dealt with the amendment to the insolvency rules and the practical aspects that need to be considered. So paragraph 3 of the Insolvency Practice Direction provides that a winding up petition will not be accepted unless it contains a statement required by Insolvency Rule 7.5 subparagraph 1, as amended by CIGA, that coronavirus has not had a financial effect on the company, or the relevant ground would apply even if coronavirus had not had a financial effect on the company. It's very important in this respect that the grounds relied upon for the purposes of the coronavirus test are set out in full.
So again, just going back very quickly to the practice direction before we get on to the PTR. It's very easy to fall foul of the new practice direction, and I have anecdotally heard of petitions that have been returned to petitioners because they haven't set out properly the grounds on which coronavirus has impacted upon the company obviously being the debtor. So it is something that you have to be very careful about. We're going to talk about the practical tips at the end, but one of the interesting questions in relation to how you prepare bringing one of these claims is effectively how front-loaded your work has to be in relation to getting the relevant information to get over the coronavirus test right at the beginning. And that's something Maria is going to talk about more, especially in relation to her case in which she successfully managed to do that just at the end of last year. Just getting on to the PTR and the preliminary hearing. So the way it works now is that the matter will be listed for a non-attendance pretrial review, where directions will be provided for a preliminary hearing as to whether it is likely that the court will be able to make an order having regard to the coronavirus test. The petition is to remain in private and cannot be advertised until the court has concluded, but is likely to make an order having regard to the coronavirus test. And just in relation to the advertisement, obviously it makes sense that the advertisement is now post this issue rather than pre-petition, because obviously by advertising a winding up petition, you're going to cause considerable damage to a company. And obviously with the coronavirus test, there's a very strong likelihood, even if you manage to reach the normal test for being able to wind up a company, but you won't be allowed to because of the extra hurdle with the coronavirus. So that's the reason why that rule has been inserted. And obviously it's something that you have to be extremely careful of, that you do not advertise before obviously this issue is being resolved by the court.
So when is the court going to be able to make such an order in light of CIGA 2020? How and under what circumstances will a petitioner be able to overcome the coronavirus test? And the main case dealing with this is the case of Re-A Company, and that was a case dealt with by ICC Judge Barber on the 12th of June 2020, where a petition was presented in a sum of around £160,000 odd, and a statutory demand was dated March 2020. This case stated that effectively few petitioners would actually be able to satisfy paragraph 2, subparagraph 4A, that coronavirus has not had a financial impact on the company.
So in that case, paragraph 2.4b was satisfied. However, going on to consider paragraph 5 of the Schedule 10, could it be demonstrated that coronavirus had a financial impact on the company before the presentation of the petition? The evidential burden of showing that coronavirus had a financial effect on the company before the presentation of the petition is on the company and not on the petitioner.
And what was important about Re-A Company is that in the case, the company had adduced no financial documents to demonstrate the financial position of the company before or after COVID hit. There was no accounts, no management accounts or projections that were provided to the court. And Judge Barber found that the threshold requirements of paragraph 5, subparagraph 1C, however, had still been met. And in that, Judge Barber stated that paragraph 5(1)(c) is clearly intended to be a low threshold, and the requirement is only simply that a financial effect must be shown, a financial effect. It is not a requirement that the pandemic be shown to be the or even a cause of the insolvency, and the term appears is intended to have a lower threshold than satisfied. Alex, do you have any helpful observations on this case?
Yeah, so I mean, the approach of a judge, as I said, the low threshold test is obviously significant, and what might be helpful is just go to some of the wording that was used in the judgment. It's a relatively short judgment, but if you look at it, you'll see that it was split into a number of issues. Issue 2 being the one that we're concentrating on today, which is the paragraph 2 and the paragraph 5 test. And what the judge said was at paragraph 27, given the petitioner's intendant's reliance on section 1231E, that's of the Insolvency Act, in the present case, the relevant provisions are paragraphs 2, 3, and 4 of Schedule 10, which we've already identified and read out earlier in this webinar. Paragraph 30, the judge said, on the evidence before me, however, the petitioner does not satisfy paragraph 24b. In my judgment, at the time of presentation, the petitioner had reasonable grounds for believing that section 1231E would apply even if coronavirus had not had a financial effect on the company. In this regard, I take into account particularly the following, and then proceeds to go through the various facts that apply to that particular case. Going on to the paragraph 5 issues, they start at paragraph 37 of the judgment. And the judge said, that being so, the next question is whether paragraph 5 of Schedule 10 to the CIG bill would, if enacted, permit the petition to proceed. So it's a two-limb test. You deal with paragraph 2 of CIGA, then you go on to paragraph 5. The judge continued to say at paragraph 39 of the judgment, in such circumstances, at the hearing of the petition, the court would next ask itself whether it appears to the court, or appeared to the court, that coronavirus had a financial effect on the company before the presentations of the petition. In my judgment, the evidential burden is showing that coronavirus had a financial effect on the company before the presentation of the petition is on the company, not on the petitioner. The judge goes on at paragraph 43 to give some reservations about the quality of the evidence that's been adduced by the company, with the debtor, in relation to the various issues. And that's something Maria is going to touch on in relation to her case. And paragraph 44, the judge says, notwithstanding these reservations, however, I would come to the conclusion that the company has met the threshold requirements of paragraph 51C. This is clearly intended to be a low threshold. The requirement is simply that a financial effect must be shown. It's not a requirement that the pandemic be shown to be the or even a cause of the company's insolvency. Moreover, the language of the provision, which requires only that it should appear to the court that coronavirus had a financial effect on the company before presentation of the petition, is in marked contrast to that employed in paragraph 5.3, where the court is required to be satisfied of given matters. The term appears must be intended to denote a lower threshold than satisfied. The evidential burden on the company for these purposes must be to establish a prima facie case, rather than to prove the financial effect relied upon as a balance of probabilities. And that's obviously extremely significant, the test in relation to it is a low threshold, and just the company, all it has to do is overcome a prima facie case. That doesn't mean that it doesn't need some evidence. And again, that's an issue that Maria is going to address when she deals with her case. So in relation to that issue, that goes to paragraph 47 of the judgment. Just a couple more excerpts that might be helpful. At paragraph 45, the judge said the petitioner would have to show that even if the financial effect of coronavirus is ignored, the company would still be insolvent within the meaning of section 1231E. And then at 47, she concludes in relation to this issue that the evidence as it stands, the court could not be satisfied that on section 1231E would apply even if coronavirus had not had a financial effect on the company. As matters stand, therefore, unless further evidence on the issues produced, there is no real chance for winding up order being made on this petition, and the petition was actually dismissed in those proceedings. And like I said, there is at the moment very limited amounts of authority out there in relation to this issue. So this seems to have very much been taken by a company as the leading authority in relation to CIGA as things stand at the moment. But as we mentioned, Maria had a recent case where she managed to overcome those burdens, and she's going to talk about that now.
Thank you, Alex. Yes, so I dealt with a case in December of last year, the case of Newman. And that is a case where I don't yet have a transcript, but my instructing solicitor was Mr. Leonard Scudder of Berkeley Row Solicitors, and he has very kindly, he's requested one, and he's happy to share that as soon as that becomes available. But this was a case that was before the Deputy ICC judge, Judge Agnello QC, and this was a case where I started off making some tentative submissions that actually the approach taken by Judge Barber in Re A Company perhaps shouldn't be the settled approach in terms of there being automatically this low threshold that automatically applies. And those submissions were very quickly given short shrift. But effectively, the facts of this case was that prior to March 2020, the petitioner owed about £175,000 in unpaid wages and a signing on fee. He had never received any salary, but also it wasn't just him, it was members of the team also who had not received a salary from June 2019 until March 2020. There was a large number of people who were sat there patiently week in, week out, waiting for their salary payments to come through, and they never came through. What was interesting about this case is that my instructing solicitor did a very good job of obtaining detailed witness evidence, not only from the petitioner, but also from the other employees, setting out effectively why the criteria in paragraph 2, subsection 4 had been satisfied. There was very detailed witness evidence from a number of people, but in contrast, there was no detailed evidence provided by the company at all. The evidence on the behalf of the company was simply one statement with no exhibited documents whatsoever. And in fact, the company, in the course of the hearing, needed to rely on some of our exhibits to try and make their points, which didn't work either. Effectively, what the company was saying was, well, you know, there was this investment that was always coming, that was stopped in its tracks by the coronavirus, that prevented the investor from traveling to Switzerland to be able to deal with the bank and to be able to get everything organized in terms of the investment. Now, this was totally very vague, the evidence. There was no evidence of who the investor was. There was no evidence of any actual agreement documenting the investment. There was no evidence of any flights having to be cancelled or anything like that. So I was able to differentiate this case from the Barber case, because at least in Barber, the court had some evidence to go on, whereas here, the court had no real cogent evidence. And there was no explanation as to why this evidence simply wasn't forthcoming. Now, another interesting feature of this case is that there had been an adjourned hearing due to COVID, which meant that actually the company even had a great deal of time in between the relisted hearing to provide further evidence. No further evidence was provided. We actually provided rebuttal evidence to the evidence of the company. And even though all of these points were raised, no further evidence was simply forthcoming.
Maria, what evidence, if in an ideal world, if you've been running the case on the other end, on the other side, if this evidence existed, what sort of evidence do you think should have been produced or would have been produced that might have influenced the court to make a different decision?
Well, if you've got a director of a company providing a witness statement, which is signed by a statement of truth, you would want there to also be exhibited some documents which support the assertions made within that statement. So some details of the elusive investment, some details of any agreements, perhaps some documentation from the investor themselves confirming the position, some perhaps emails demonstrating that flights had been cancelled. It was just so inherently vague, and that's a phrase that the judge used in her judgment. She said there was weak evidence, and she said that although the threshold was low, the evidence put forward on behalf of the petitioner and the supporting evidence actually demonstrated that this was effectively a litany of broken promises that these employees had to work through. There was also, my solicitor did a very good job of putting forward some documents from Companies House, just stuff that was publicly available, which confirmed that actually the financial position of the company before the pandemic even started was in a very dire situation as well. So that evidence was helpful. The judge also made a remark in her judgment that, well, you know, this is all very well, the company saying that this investment was cut short by COVID because people weren't able to travel to secure the deal. But as we know, the travel restrictions eased in July, and yet there is still no evidence as to why this didn't take place, this deal didn't get sorted, or the debt still remained unpaid. And this hearing was heard in December of 2020. So the judge was very critical of the lack of evidence in this case, which I think is fair when one compares this case to the case of Rie Company. At least in Rie Company, the court had a starting point of some evidence, whereas here, in contrast, actually, the court didn't have a great deal at all.
So in terms of sort of takeaways in this, I mean, the company, I mean, they have a low threshold test to reach a prima facie case, but they can't do it to wing on a prayer. They need to have
Exactly.
they need to have something to hang their hat on in relation to some financial evidence that they've been impacted post-COVID. But you would think would be pretty easy for a company to produce if they had proper accounts. And as you said, you know, if it's a question of meetings being cancelled or other substantive thing, you know, some real evidence of that, you know, receipts, messages from airlines, cancelled meetings,
Absolutely.
yeah.
And I was very critical that the evidence appeared to lack any real credibility. You know, if somebody is saying something in a witness statement supported by a statement of truth, then get all the facts in there that they need, get the supporting documentation in there. And it was just a very vague statement, didn't really address much, didn't go to the core issues, didn't go to the core evidence that was needed. But I think what is important about this case is that it was also an extraordinary factual set of circumstances that enabled the court to actually be satisfied that it could indeed make such an order. And those extraordinary sets of facts were in fact that it's not just one employee, but there was a whole load of employees that hadn't been paid for a large number of time. And I was able to, in my skeleton, do a chronology which referred to emails going back and forth every week saying, don't worry, payment will be coming soon, you don't need to worry, we thank you all for your patience. This was an extraordinary set of circumstances indeed.
So just before we get on to practical tips, when you say extraordinary, if you're a solicitor making an assessment of whether you should be bringing one of these petitions at the moment, and we know from, you know, as we've been contacted by many solicitors since the original recording of this webinar, that there are a lot of people in, not surprisingly, exactly in this position. In terms of them, using the word extraordinary, how would you rate the chances in terms of, if you've got some real evidence that the debt was owed pre-coronavirus, and you can establish that, and if you have some real evidence that the debt would have fallen due regardless of the circumstances of it, but the company can produce some evidence that they've been impacted subsequently to coronavirus, how much encouragement should solicitors take from your judgment in relation to going and testing the waters and bringing these claims where the
Well,
evidence?
yeah, I think they should be encouraged. I mean, Alex, do you not think it's quite encouraging? I don't think they should be disheartened and feel like they have no chance at all. I feel like as long as they can gather good, cogent evidence, which is what we had in our case, then they should be able to satisfy the test.
No, I agree. I mean, I think I can understandably, for cost reasons, people have been very reluctant to put these claims in since we're a company, totally understandably from clients' point of view. But no doubt there is an awful lot of frustration in terms of, you know, the collection of debts, and also this we'll talk about maybe a little bit at the end. Sometimes maybe the misuse of debtors of Schedule 10 to hide behind as an excuse not to pay their debts, knowing that they're in pretty strong ground to stop being wound up. I mean, my personal opinion on it is it's all about the preparation of the evidence before, and getting your ducks in a row before you bring the petition. If you manage to get some coherent evidence and some good evidence, I don't see any reason why, if you can show it's a pre-petition debt, or that the debt would have fell anyway, why it shouldn't succeed. I mean, like in one of my matters, we got judgment in June, end of June, beginning of July, for £3 million in the High Court, for a Russian client I was representing, and because obviously we could show that the judgment debt fell due, and it was related to a pre-COVID matter. The other side didn't even try and oppose, as successfully wound up the company. So I do think that your case should be some encouragement to solicitors. They still need to be cautious, but in the right case to bring these petitions. And though we, a company, still very much is good law, and the low threshold test is very much still there, it does show that, you know, with the right preparation, it can be overcome. That's my personal view on it.
Yeah, no, absolutely. And some of the communications we've received, Alex, demonstrates that actually a number of solicitors have these preliminary hearings approaching. So it'll be good to see the outcome that comes from their hearings. So I think definitely watch this space.
And we'd certainly be very interested if anyone has got any unreported cases in relation to this, they've had any petitions that have been successful, or likewise, if anyone's got any petitions in the pipeline that are coming up and want to reach out, more than happy to talk to anyone. And like I said, hopefully Maria will have her transcript soon in her matter, which hopefully can be deployed by petitioning creditors to at least add a little bit of nuance to rear company. Just getting on to some practical tips in relation to this. Be mindful of paragraph 6 of the Insolvency Practice Direction and the requirement to serve witness evidence. So provide detailed witness evidence if you appear for the petitioner or the company. We've already talked about this. And this will require cases to effectively be front-loaded from the start. Whilst the evidential threshold for a company is low, it still exists. Do not assume that the threshold test will be easily met. Do not be complacent. File supporting evidence from other witnesses, but only where it is really going to add to the extraordinary facts. File any objective evidence, i.e. company's house documents, financial statements, etc. Just on the last point, in my personal experience, I've got a matter where a client is owed a large sum of money, several million, and they have been seriously considering issuing up a winding up petition because there is quite a lot of money at stake, and therefore there's more of an appetite to spend funds pre-petition. My instructing solicitors are seriously considering at the moment whether to instruct independent, not experts, because there wouldn't be expert evidence as such, but to get a proper analysis done by one of the big accountancy outfits, and they control a lot of public data and filings. It's not the cheapest exercise in the world, but if you do want to get your evidence in good shape forward, it's certainly something worth considering. On the other hand, if you're defending one of these claims, it would certainly seem very sensible to get a statement from either this chief financial officer or the external accountants to back up in figures what you're asserting, which is exactly what they don't seem to have done properly in Maria's case. So those are both important considerations on either side of this debate. So we get to the last slide. This is where in the original recording we moved into the Q&A. So we're gonna keep this very brief, as we don't have an audience this time to bounce off. But maybe very quickly we can just work through the points here, and both of us put our 2 pennies into what we think about each issue. So the first one is, have debtors been hiding behind CIGA to not pay their debts, knowing that it's unlikely they will be wound up? I mean, Maria, what's your view on that?
I'm sure that's definitely taken place. What do you think, Alex?
From what I've heard, I've had lots of phone calls from lots of solicitors complaining precisely about this, both before the first webinar and afterwards. So I'm very sure it's going on, and I've seen it myself in correspondence on matters that I'm dealing with. That debtors have, I think it would be generous to say, put forward somewhat unrealistic defences to claims, and then said, oh, well, you know, we got Schedule 10 to fall back on anyway, so you can't bring a petition. Not quite in those words, but not far off. So I think it has been abused. And in my personal opinion, very much is my personal opinion, this CIGA needs to go sooner rather than later.
Really?
Yeah, that's in my personal opinion. It's been a year now.
Yeah.
The economy's been effectively on a huge artificial intravenous drip for the last year. And birth of companies is important, the life of companies is important, but the orderly death of companies is also important.
Absolutely.
And insolvency is there for a reason. It's normally the last recourse, but it's an important part of our commercial system. So in my opinion, it would be unfortunate if it was renewed for another 3 months. If it just goes to the end of April, which I'm hearing might be the case, then that's not the end of the world. But I certainly know anecdotally from instructing solicitors and other people who've been in contact that there is going to be a deluge of stat demands being issued when CIGA falls away. And that's only going to get worse with time.
And so what about the threshold test? Do we think the threshold test is too low? Because obviously I tried to make those points in my case unsuccessfully, of course.
Yeah.
But you know, where does this low threshold come from? It just comes from those words, the interpretation of the words in the statute.
Yeah, Judge Barber's very much, she's concentrating on the words appear rather than shall or must or etc. I mean, I totally understand where the judge is coming from in relation to that. In my opinion, the court might have been maybe a little more robust in terms of the test. I mean, clearly, you know, it's not intended to be an onerous burden on the company. Whether it's to a lower test is certainly open to debate. I think certainly your case has helped in even despite what the judge might have said about the low threshold test, rein it back a little bit to at least give some realms of reality to it. So if a company comes along, like they did in your case, effectively with virtually no evidence, and just saying, well, this is the way it is, and it's a low test, so thank you very much, we should have a get out of jail free card. That, I think your case has pretty much kicked that into touch. So
well, I'm looking forward to the opportunity when you do have a preliminary hearing on this point before Judge Barber, and she kicks you back on
well,
this low threshold.
I'm not sure Judge Barber would disagree with anything we're saying. I mean, she dealt with the facts of that case as they were, and it's
a very good judgment, very detailed judgment.
Well, she's a very well-respected insolvency judge, so she knows what she's doing, and hence even why, you know, it's not a high court authority. It's still one that that carries an awful lot of weight, and I can't see that threshold test being overcome anytime soon, and I don't think CIGA is going to be around with us long enough for that to change. So that's just a reality, I'm afraid, that someone's going to have to deal with. Obviously, if you're for the creditor, petitioning creditor, that's unfortunate, and you just have to take that into account in your advice. And no doubt, if you're acting for the debtor, that might, you know, be something you take into account when you're advising a debtor in relation to being threatened with a winder as well. So that's my views on that. Okay, the first question is from Robert Stevenson, and it says these conditions apply when, I'm not sure what conditions he means, but when the debt arose or at the time of enforcement. Presumably this is in relation to the two-limb test in respect to paragraph 2 and paragraph 5, of which the answer is it's with enforcement. The provisions apply regardless of when the debt is due. What the court can take into consideration is when the debt fell due. For example, in Bria Company, obviously the debt fell due before these provisions were in place, and that's something that the court took into consideration. But in that particular case, they did give the injunction restraining the advertising of the petition. But in Maria's case, and she can elaborate on this, from what I understand is that the debt also well predated the application. I understand it was about 9 months before, and that, from what I understand, was an important consideration in the court making the determination that it did. Is that correct?
Yes, that's right.
Okay, the next question is, and I hope I'm pronouncing it correctly, Linda de la Sun. And the question is, didn't think you could advertise until after service. So does the court set the PTR after service? Well, yes, that's exactly how it works. You're under the practice direction, you're prohibited from advertising before serving the petition. And like I said, there's an obvious reason for that, because obviously you damage a company sometimes irreparably by advertising for a petition to wind up. So they have set up this specific mechanism under the practice direction where you submit the petition to the court. Like I said, it's important to have your coronavirus grounds in the petition itself, or they will reject the petition. And then it will go to the administrative PTR, and then they will determine whether it needs to go to a full preliminary hearing, i.e. there's a live issue between the parties on Schedule 10, which is exactly what happened in Maria's case. In your case, Maria, how long did it take between the PTR to get the matter heard?
Well, my case was unusual in that it was adjourned off because of COVID. But yeah, I mean, it was listed probably about 8 weeks later. So all in all, it was about 3 months. Right. But mine was an unusual situation.
I imagine now that the courts are more used to it. These will get listed quicker. In relation of service of evidence, were there directions given in terms of service of evidence by both parties after the pre-trial review, but before the actual hearing of the matter?
Yeah, no, absolutely. What happens is you will be given set directions for the preliminary hearing itself. So there would be, you know, an opportunity for the petitioner to file its evidence, an opportunity for the company to file its evidence, and then we actually filed rebuttal evidence in response. So we were all over it in terms of the evidential position, and that's important because the court needs to see the evidence to be able to determine the issues at the preliminary hearing itself.
Okay, and just scrolling down the questions, because this is a question for you, Maria, from Richard Anderson from Beswicks. On Maria's case, I'm interested to know, has payment been made by the debtor company, or has the petition been listed yet and heard?
It hasn't been made. The petition has been listed, but I believe the matter is still ongoing. I wasn't instructed on the final hearing, but it was listed pretty soon. But they never paid the money, and I believe there's still a massive dispute going on with all the employees.
Yeah.
And in relation to that case, I should have mentioned my instructing solicitor has requested a copy of the transcript, and as soon as that becomes available, if anybody would like that, please just email me and I will forward your email on to him. He's happy to share that around because obviously it is a helpful judgment.
Anecdotally, I did a winders list, which I hadn't done for some time, late last year, which was, we had a judgment debt of £3 million arising out of a High Court trial, which we did in June, July. It was on a Russian case that I was doing. And once we submitted the petition, nothing was put in by the company. So it flew through the administrative PTR. We had in our witness statement addressed the coronavirus issues, but we hadn't done it in great detail at that stage, even though we had quite a lot of financial information about the debtor because we had full disclosure in the proceedings. And then when it went into the normal winder list, which is now, I don't know if any of you have seen it, it actually works quite well. It's done remotely on video. You're given effectively a code for a 10-minute segment, and it worked much like as it normally did in the roles building. The only difference in terms of asking for the usual order is that the judge normally would like just a little bit of background, specifically addressing the coronavirus issue. Certainly that's what I saw. So if anyone is doing the winder list, it's certainly good to have a chronology and know where various things have happened rather than just ask for the usual order.
Alex, just an update on my case. My instructing solicitor has just messaged me actually to say that they're still chasing the company and also the directors in relation to my matter. So that's an update on where my case is at the moment.
Maria, there's another question which is about your case, which I'm going to read out for you, from Tobias Haynes at Martin K. Solicitors. Maria, in your case, why do you think that the judge had to go so far as to consider your case extraordinary? It seems to me that paragraph 24B, schedule 10, CIGA, is a causative test, i.e. did coronavirus really cause the insolvency? In your case, it seems you had to jump through a lot of hoops when para 24B seems quite broad.
Yeah, well, first of all, hello, Tobias. I know Tobias very well. It's good to have you on here. Well, I think essentially because the approach the judge had already taken, Judge Barber and Rie Company, of it really being a low threshold, I think the reality is under the first part of a test, it's often very difficult to establish that coronavirus has not had any financial impact on the company. And of course, even in my case, whilst that wasn't part of her judgment, the reality is that there would have been some impact. But I think the reality is that my extraordinary set of circumstances justified her making the decision she did, because the debt had gone on for so long prior to COVID actually hitting.
Okay, and there's a question. This is from someone who's anonymous, but it touches on your case as well. It's a practical question. How does one go about obtaining relevant witness statement evidence from third parties about circumstances demonstrating the debtor's insolvency prior to March 2020 in circumstances where the petition must remain private until a judge has considered that the coronavirus test is met?
Well, I think in my case, again, and what was unique about my case is that obviously we had a whole group of employees that hadn't been paid for some time. So they were all in talks with each other about what this situation was that was occurring in front of them. They had, various methods of communication set up between themselves, and they fully understood and were aware of what was happening with my petitioner and his case, and they wanted to support that. And my solicitor was able to investigate matters fully. He was able to get that evidence because they were already aware, they were in it themselves, so they knew exactly what was going on, and that was the situation. So that evidence in that case was perfectly easy to obtain, and indeed all the employees, they're still sticking together in terms of any other action that's going to be taken in the future.
Okay, and there's a question which is funny enough, touches on a matter that I've been dealing with, which is from Cecile Gill at Maria Solicitors. And the question is, what about expert evidence from the company accountant? Well, I suppose from the company's point of view, there's absolutely no reason. In fact, it's probably a sensible approach to get something signed off in terms of a witness statement, setting out the financial position of the company and it's been impacted by coronavirus. I think that would be extremely cogent evidence. I'm not sure it would necessarily be considered expert evidence if it's from the company accountant, because expert evidence is third-party evidence, while the company accountant, though he might be an expert in accountancy, wouldn't be classified as an expert. You wouldn't need to get leave from the court to get an expert to get their evidence from that, because he's giving first-hand evidence. What the scenario that I've had on one of my matters, without divulging too much about it, is that my clients are owed a considerable debt of several million, and they have been seriously considering about issuing a petition. In their view, that debt is undoubtedly due, and I think there's certainly a good argument from that, though solicitors on the other side might argue differently. And one of the things that we've been of doing a forensic analysis in relation to the company. In that case, it was something worth considering because they were owed several million and there was enough money in the pot, so to speak, to considering going down that road, and the client may well still go down that road. And the reality, though, is it is difficult to argue that a company has not been financially impacted by coronavirus with the low test in the prima facie case. It's not difficult for a company to establish that. What seems to be a much more likely ground to succeed, and which is the ground that obviously Maria succeeded on her case, is that the debt would have fallen due anyway. And that seems to be a much more fruitful area for the petitioning creditor to concentrate on. Was that your experience in your case, Maria?
Yeah, absolutely. I'd be interested, Alex, has anybody popped on the comments about the experiences they've had? Because I've not heard of many other people pressing these matters to a preliminary hearing. Has anyone done that? Has anyone succeeded like I did, or are people just wary and not proceeding?
I haven't seen it on the Q&A. I've seen there's a lot of chat messages which I'm not reading. They're popping up in front of me, and when I commented that I think that there are lots of debtors hiding behind Schedule 10, quite a few comments popped up in chat agreeing with that. So if someone has got an experience of that, just to make it easier for me to find, would you please put in the Q&A, because it would be very interesting to know, because though I've had experience in terms of dealing with the issues around it, I haven't actually had a matter that's actually gone to a full hearing. And Maria having gone to a full hearing, I think they've been relatively rare, hence the lack of authority really on this. There's only 2 or 3 cases really that have been reported on this, and like I said, Re & Company seems to be the leading one. So if anyone could put in Q&A about what their experiences have been in relation to making these applications, and if they've got any good tips they would like to share, I'd be very happy to read them out. While we're doing that, there's a double question, which it's 2 questions, but I'll combine them, because I think, again, Marie, you're probably best to deal with them. There is a question from Abdul Hafizi at Freeman Harris about, do costs follow the event, which I assume they do, but I'll pass them on to Maria. I don't see why they wouldn't. And Aziz Rahman has asked, if a creditor issues a stat demand under section 123 and the creditor refuses to agree to withdraw it, can the debtor apply for an injunction to prevent a winding up petition being issued under the moratorium?
Well, I can deal with the first question. In my case, yes, certainly, costs follow the event. So that was the position in respect of costs.
Yeah, in respect of the second issue, well, at the moment, obviously, there's a prohibition on issuing stat demand under section 123. It's dealt with under paragraph 1 of Schedule 10. As you all know, you're not required in corporate insolvency to issue a stat demand. It is a mechanism for getting up to a winding petition, but it is not required. So the short answer is yes. You can make an application, but under the new procedure, you don't really need to, because the stat demand doesn't bite at the moment. And if they want to petition for winding up, then they have to go for the practice direction procedure anyway. So they would have to establish on their petition that there were grounds to get around the coronavirus test. And then obviously if those matters are contested, then it would go to preliminary hearing. So the stat demand at the moment, as things stand, is a little bit of a red herring. Obviously, if this legislation is not extended after the 31st of March, I wouldn't be surprised if there was a glut of stat demands being issued all over the country. I imagine particularly in commercial real estate and other areas, and then we're going to have a very busy time in the insolvency courts.
Yeah, absolutely.
I've noticed it's 10:28, and we've been told that we have a hard stop at 10:30. So yeah. maybe I can just raise one more thing in the Q&A, because this is someone who's got an ongoing case.
Okay.
A gentleman called Steve Dillon. I have a preliminary hearing listed on May on these issues, now debating how extraordinary we are, but similar in terms of debt falling due August 2019. issue for us as a payment plan? Well, that sounds like a question for you, Maria.
Yeah, well, I think I think obviously every set of facts are unique, but I'm sure there's something about your factual situation which actually could be extraordinary. So it's certainly something we can discuss, and please feel free to send me an email should you want to discuss that further. Okay, wonderful. So we've now reached the end of the slides. So in the original webinar, we had a large number of questions that we spent a long time going through with people. We also received a number of emails following the webinar. So please, if you do have any questions, please do reach out on our emails, which you can see there. And Alex and I will both come back to you, any queries whatsoever. And Alex, I think that concludes everything.
It is, and just for anyone who's watching this for the second time, if anyone is, just thank you very much for all the kind emails that we got after the last webinar. And like I said, we'll no doubt update everyone when we know ourselves what's happening with CIGA and if it's going to be extended.
Okay. Excellent. So I'm going to close the meeting down now, Alex. Thank you again. Thank you everyone for being patient with us, and have a good weekend.